Mr. Fox.
As your lordships know, I appear with Mr. Schwager for the appellant and my learned friends, Mr. Ravinovitz, Mr. Pilbro and Mr. Venkatasan appear for the respondents. My lords, by some strange quirk of fate, I think this may be the third Brussels or Lugano case to come to this court since the 23rd of June last year. On this occasion, we're concerned with Section 5, matters relating to individual contracts of employment. Now, my lords, in important respects, I think it is fair to say the case being run by the respondent with a view to upholding the Court of Appeal's judgment differs very significantly from the reasoning the Court of Appeal used to arrive at that judgment. That is so even though but a few months ago the Court of Appeal judgment was described by the respondents as definitive. Now, we make no complaint about that because 6 months is a long time in litigation, but it does mean we have rather a lot to get through in the course of the allotted time. Now, my lords, given that, I was hoping to reduce the preliminaries before diving into the argument to the very minimum necessary.
Good. Well, if it is this, we've read the very helpfully very full cases and responses and the judgments below.
My lord, I'm obliged.
So you can assume that we already have read them.
My lord, being a jurisdiction appeal, we're obviously here without my clients having served a defence.
Yes.
Or set out in the context of the jurisdiction case their arguments on the merits. Given that, it ought to be possible to conduct this appeal on the basis that the claim put against them meets the relevant threshold of arguability, but is strenuously denied. And beyond that, any issue of merit should be entirely irrelevant to the issues before your lordship's court today. There are places in my learned friend's case which would seek to persuade your lordship that the case is not only arguable, but clear. Now, my lords, had we but whirled enough in time, no doubt I could set about showing your lordships it's not only not clear, but improbable.
We are going to be coy.
My lord, I'm grateful. I think there is only time for coyness, and I don't propose to say anything more about it, but I would not want that forensic restraint to be taken as in any way an acceptance of the allegations. Now, my lords, it's no coincidence that we begin our submissions before your lordships on the one case which we say is binding authority even in this court on the relationship between Section 5 and Articles 5.1 and 5.3 of the Brussels or Lugano regime, and that is the decision of the Court of Justice in Holterman. It's a case that you get to rather later, it's fair to say, in the respondent's batting order. Now, Lords, I know the two cases go through Holterman at some length, but we do say it is the key issue, key authority on the first case. And in those circumstances, I'm going to hope to trouble your lordship's attention with a few further submissions upon it. Now, my lord, there is much common ground. We have the Holterman case in the authorities bundle volume 4, tab 51, beginning at page 2324. It may be helpful to note the three provisions of Dutch private law that form the basis of the causes of action. The first was a claim under Article 2.9, which appears in Book 2 of the Civil Code of the Netherlands. Book 2 is concerned with legal persons, and Article 2.9 sets out the obligations of a director of legal persons. And, my lords, it's quoted in the judgment at page 2347.
Thank you.
And that is a duty occasionally referred to either in the judgment itself or in the submissions as the duties owed by Mr. Spies as a director in the company law sense.
That's at the bottom of the page.
My lord, yes.
Thank you.
And, my lord, it is a more stringent duty, as we shall see, that which is owed by employees. That is something that the Dutch Advocate General had noted in the Dutch Supreme Court, but it's absolutely clear from the face of the relevant provisions anyway.
Yep.
The second claim was under Article 6.162 of Book 6 of the Dutch Civil Code.
Next paragraph, yeah.
Next paragraph. That is the generalised tort obligation that one finds, for example, in Article 1382 of the French Civil Code, and one sees references in the course of the submissions and the judgment to unlawful conduct, and that is a reference to this tort law cause of action, at least tort law for national law purposes. And Lord, finally, there's Article 7661 of Book 7.
Yep.
That is a book concerned with particular contracts. Title 10 is concerned with employment contracts. And one sees from paragraph 11 of the judgment, page 2348, that employees are only liable to their employer where the loss or harm results from, as it's translated here, deceit or recklessness. One sees other translations, intentional loss or recklessness. The French translation of this judgment uses the word dol, but plainly the idea is that of intentionally or recklessly caused loss.
What is the nature of the liability referred to in paragraph 9 of this judgment? One gathers that paragraph 10 deals with delictual liability and paragraph 11 with contractual liability of a specific kind. What about the paragraph 9 liability? Is that a sort of breach of statutory duty?
My Lord, it's a statutory obligation that follows from, we would say, the voluntary assumption of a particular office, in that case, the office of director of a company.
So it's not contractual?
It is, in national law terms, not contractual, albeit, as we shall see, or your Lordships would have seen, for Article 5153 purposes, the view of the ECJ was that if the office was assumed voluntarily, or the relationship, then the obligations that attach to that office can be characterised as a matter relating to contract for the purposes of Article 5.1.
Right.
Now, Lord, the questions that the Dutch Supreme Court asked the ECJ to answer are at paragraph 16 of the Advocate General's submissions, which we have at page 2330 of this bundle.
Yep.
And my Lord, the first of those questions, the terms in which it is phrased are very significant. Do Articles 18 to 21 preclude the application of Articles 5.1 and 5.3? So as this case makes its way to the ECJ, one issue absolutely squarely on the table is, does Section 5, the employment regime, preclude the application of Article 5.3? And your Lordships will see that encompassed within that question, there's reference to the defendant being sued in his capacity as director of that company on the basis of improper performance of his duties. That's the Article 2.9, duty of a director to legal persons. And the reference to on the basis of unlawful conduct, that is the tort claim that we looked at a moment ago in the Dutch Civil Code, and also on the basis of deceit or recklessness in the performance of the contract of employment, reflecting the fact that under Dutch law, it is only when an employee acts with one of those two states of mind that there is liability to the employer.
That formulation seems to assume that the article that the paragraph 9, liability to legal persons, liability is to be classified as contractual.
Lord, in the Arnhem Court of Appeal, the court had held, I think, that Article 2.9 was sui generis and didn't fall within 5.153.
Right.
I think it is fair to say that the Dutch Supreme Court, when they come to make this reference, are of the view it may well be a matter relating to contract.
Otherwise, the question doesn't make much sense.
My Lord, no. But, my Lord, what is significant for present purposes is that in the formulation of their case before your Lordships, the respondents say that a claim that falls within Article 5.3 could never come within Section 5 of the Judgment Regulation or the Lugano Convention, because they say the words in matters relating to contract are simply providing a special subset regime for claims that would otherwise fall within Article 5.1, and that claims that do not fall within Article 5.1 but 5.3 fall outside Section 5 altogether. So, my Lord, if the law as decided by Halterman was as Arcadia would have you take it to be, one would expect a very clear answer that Articles 18 to 21 can never preclude the operation of Article 5.3, because by definition, a claim which falls within Article 5.3 is not going to be within Section 5, dealing with matters relating to individual contracts of employment. And, my Lords, you will search in vain for that clear statement. On the contrary, you will get a very clear recognition from the ECJ that claims that might otherwise fall within Article 5.3 are capable of falling within Section 5, and therefore Article 5.3 is capable of being precluded by Section 5.
But you say we search in vain for such a clear statement in that direction. Do we find a clear statement in the opposite direction?
My Lord, yes, to this extent, that any statement by the Court of Justice to the effect that Section 5 will preclude the operation of Article 5.3 if particular facts are found, and we'll see that that is their answer in relation to question 1, necessarily establishes that Section 5 is capable of applying to claims which outside an employment context would fall within Article 5.3.
Can you just give us a reference to those statements?
Lord, if one goes to the answers at the end on page 2358, for example,
Yeah.
these are the references both to Article 5.1 and 5.3, just below letter D. My Lord, there are other aspects of the structure of the judgment which make that clear, and I was proposing to take your Lordships through those aspects.
So just under D we find the answer?
Just under D. There is an and in other translations of this judgment, but...
Where is the and?
There isn't an and in this version, but there is.
Where might it appear?
Between the subparagraph 1 and the subparagraph 3.
Sure, I don't follow that.
Yeah,
Whereabouts?
5.1, brackets 1, close brackets, and brackets 3, close brackets.
My Lord, yes.
Ah.
Oh, I see. There.
Thank you.
Yeah, that makes sense.
Now, my Lords, if one comes back to the second and third questions on page 2331,
Yep.
those separate out the 5.1 and the 5.3 issues. The second question is concerned with 5.1. It is framed only to arise if the answer to the first question is in the negative, i.e. no preclusion. The second question does not address the unlawful conduct. It only addresses the status of the company law claim, the Article 2.9. And one then has the third question, separating out the Article 5.3 issue, again framed on the premise that question 1 has been answered in the negative, no preclusion of Article 5.3. And by contrast, that does pick up within the question unlawful conduct, as well as breach of the company law duties. Now, I accept that that is the question from the referring court, but as we shall see, the CJEU also answer question number 3 on the hypothesis it only arises if the answer to question 1 is in the negative, i.e., the Article 5.3 claim will not arise at all as an issue for consideration if question 1 has been answered that Section 5 precludes 5.1 and 5.3. And once again, that is impossible, we say, to reconcile with a submission that claims that would otherwise fall within 5.3 are never going to engage Section 5.
Yeah.
Now, my lords, the proceedings before the Court of Justice became more complicated than those referred because the Commission raised a new issue of whether Mr. Spies was an employee at all, reflecting the fact that Holterman was basically a company in which Mr. Holterman had an 85% shareholding and Mr. Spies had a 15% shareholding. And one sees that one of the issues the Commission raised is Mr. Spies an employee at all? Is the necessary subordination in his role present? That's not a question that the Court of Justice provide the answer to. That's a matter referred back to the National Court. But it does have the consequence that the judgment is being given without it yet having been determined definitively whether Mr. Spies is an employee or not. Now, my lords, given the time constraints, I was going to focus on the court's judgment rather than on the Advocate General's opinion, at least because we say the court departed in significant respect from that opinion. But there are two matters that I did want to pick up from the opinion. The first is simply to note on page 2332 the submissions of the German government.
Yeah.
Which were that Section 5 precludes Article 5.1 and Article 5.3. And they give as their reason for that submission, it's consistent with protecting the weaker contractive party, which is the objective being pursued by Section 5. And Lord, I mention that because it is fair to say that in commentary you will find German commentators more generally support a view that Section 5 only applies to Article 5.1 type claims. That in part reflects the fact that the German language version of Section 5, which includes, I think, reference to claims derived from an individual contract of employment, is rather more sympathetic to that argument than the English or the French language versions. But it is significant that the German government, at least, were arguing for a position that Section 5 trumped Article 5.3. And my lord, the second matter of significance is the way in which the Advocate General suggested the question should be answered. One sees that at paragraph 67.1 in particular, on page 2343. Because, my lords, he did not use the language of Section 5 precluding Articles 5.1 and 5.3, which had featured in the question formulated by the referring court.
So which paragraph was this?
This is paragraph 67, subparagraph 1, my lord, 2343. He used language derived from the German language version that claims will be precluded if the claim brought derives from the individual contract of employment. In other words, if the conduct complained of may be considered failure to perform contractual obligations which may be established by taking into account the purpose of the contract of employment in question. So an answer to the question which certainly was heavily influenced by the wording in Brogsitter in its formulation and which eschewed any reference to Article 5.1 and 5.3. And my lords, if that is the formulation that the Court of Justice had used in answering the first question, I accept that my argument on Holterman would be considerably less straightforward than it is. My lord, it was not. They reverted back, as we have seen, to the language of Section 5, or Articles 18 to 21, precluding the operation of Articles 5.1 and 5.3.
Right, that's the Advocate General then. Yep.
Now, the judgment, if we can pick it up briefly at paragraph 25, page 2349, just to note that the Arnhem Court of Appeal had found Section 5 precludes Article 5.3 type claims as well as Article 5.1 type claims. So the question posed by the Supreme Court was clearly intended to address this very issue because that was the issue which the Arnhem Court of Appeal had found. Now, my lord, there are some paragraphs which make preliminary observations at 2351. paragraphs 31 and 32.
Yep.
And those are preliminary observations to all three questions raised. And in those preliminary observations, the court is making the rather obvious point that simply because you have one action that brings three separate claims, and you're relying on different provisions of the convention or the regulation to establish jurisdiction, it's not enough that one of those claims falls within that head to get the others in. All three claims would have to fall within the relevant head of jurisdiction for that court to have jurisdiction on all three claims. It's a statement of really an obvious proposition, but nonetheless one the court made at the outset before diving into the first question, which we are mostly concerned with, which I've referred to as
Do they decide each claim separately, do they, from jurisdiction?
Well, having answered the terms in which...
Not clear.
Well, the terms in which they answer the first question make it clear that claims will fall within Section 5, whether they are claims which would independently be 5.1 or 5.3. So they have held...
This simply reflects the rejection of the concept of forum conveniens in the whole of the scheme of the regulation.
My Lord, yes, and perhaps a rejection of the argument already rejected in Calphalis, that it's not enough to have a connection between different claims for them all to be brought within the same provision.
The fundamental difference between the regulation-based approach and what we would do as a matter of English common law. If the regulations didn't apply.
Well, it's subject to the gateway. That's absolutely right. I mean, even on gateway terms, I think there have been occasions when claims of different causes of action have been left to different courts. But... So, my Lord, the answer to the first question begins at 2351.
Yep.
Your Lordships will not find any reference to Brogsitter in the entire answer to that question. You will not find any reference to the distinction which the respondents now seek to draw between tort claims where the wrong is only actionable because of a voluntary undertaking and tort claims which effectively sit on a right which exists as against the world. That is entirely absent from this analysis. Instead, at paragraph 49 on page 2353, one finds the answer that in a situation such as that at issue in the main proceedings, in which a company sues a person who performs the duties of director, and that person in the performance of his duties, and to establish misconduct on the part of that person in the performance of his duties, Section 5 must be interpreted as meaning that they preclude the application of Article 5.1 and 5.3. And then the following words, obviously, provided the person is indeed an employee. And that was picking up the fact that the Commission have raised this fresh point on the appeal. Is Mr. Spees an employee at all? The court have given some guidance on how that question is to be answered. And so, of course, their answer to the first question is all conditional upon the National Court finding that he is indeed an employee. But, my Lord, it is, we say, a complete answer to the first point raised on this appeal, that the Court of Justice plainly regarded Section 5 as precluding the operation of Article 5.3 as well as 5.1, where the claim was brought to establish misconduct on the part of the employee in the performance of his duties.
Was this point argued, though? Because I mean, it looks as if from paragraph 42 onwards, indeed perhaps from earlier, the real issue is the Commission one. Was this chap an employee at all?
Well, Lord,
I mean, yes, paragraph 40, you go back, the issue of subordination, and paragraph 35 and 36, the issue of classifying the connection between Mr. Spees and the company, etc., etc. So the whole of this question seems to be dealing with the question whether... Yeah, and paragraph 34, the whole of the first question is dealing with the question whether he was really an employee.
My Lord,
I mean, they weren't focusing on the talk point at all. It seemed to be caught up with the question, but perhaps it wasn't ever suggested that if he was not an employee, that this amounted to a tort claim which couldn't be or shouldn't be analysed as a contractual one.
my Lord, we would say the answer to that is this, that the was he an employee issue wasn't even an issue being run in the Dutch proceedings.
No, but I mean, it was certainly seems to be the whole burden of the first question.
They must have assumed that he was an employee because they referred to the question whether he was or not to the Dutch courts as not being a question of European law. So that the whole of this analysis appears to
I don't
proceed.
think that's right. If you look at paragraph 40, they refer to the independent concept of a contract of employment, presupposing a relationship of subordination of the employee to the employer. As I see it, I mean, that from 34 onwards, or possibly from 33 onwards, the whole question is, could he be classified as a worker, i.e. an employee? There isn't a definition, they say, of individual contract of employment in 35 and so on. It's an independent, autonomous concept, what a contract of employment is.
That is certainly a live issue before the court. It's not a live issue in the Dutch
No,
courts.
I've got that.
And well, when it comes back to the Dutch courts, there's some surprise because people say, well, of course he's an employee, and therefore we move straight along to apply.
Yeah.
But the addition of that issue by the Commission cannot, we say, take away the fact that the court is answering the issue referred to them by the Dutch court as well. Does Section 5 preclude Article 5.1 and 5.3?
How helpful is this case in view of the way the case seems to have been pleaded? If one looks at paragraph 19 of the judgment on page 2349, it all seems to have been, all the allegations were linked to the contract of management and contract of employment, weren't they? Whereas here, the gravamen of the argument against you, as I understand it, is primarily that the claim is not put on the basis of contract. Whereas here it does seem to have been. So the point at issue wasn't really the point they were considering, rather bearing out what Lord Mance was putting to, I think.
Well, my Lord, that rather involves the suggestion that all of the references to Article 5.3 given in the course of this case result from some oversight or misnomer.
Precisely.
And because the case put against me is that a 5.3 claim can never come within Section 5. My Lords, if one goes on and looks, for example, at how the third question is answered,
Yeah.
para 67 on 2356, courts say it only arises if he's not an employee. Plainly clear within that is if he is an employee, even if it was a claim that might otherwise be within 5.3, 5.3 doesn't apply because of Section 5. And my Lords, they had not yet decided, as Arcadia would have you believe, that none of these were claims which were capable of falling within 5.3, because that is the very issue they refer back to the Dutch court to decide. One looks, for example, at paragraph 79 of the judgment on 2357 to give some guidance on the answer to the 5.3 question, which only arises if he's not an employee, and leaves the Dutch court then to provide the answer to that question. So, my Lord, it cannot be said, as Arcadia say, well, Holterman is explicable on the basis that they'd already decided that none of the claims were capable of falling within 5.3. They plainly had not decided that, hence question 3 and the referral back to the Dutch court. And plainly what they did decide in Holterman is that when you are suing to establish misconduct on the part of someone who is an employee, Section 5 precludes 5.1 and 5.3.
Yes, I see.
And we'll just sort of finally on this before looking at the fate of the case when it comes back. If one looks at the terms of the first question asked of the court, which absolutely squarely asks the question that one might otherwise be asking this court to ask of the Court of Justice, does Section 5 preclude 5.3 claims as well as 5.1 claims? And given the answer that is received, we would submit it is extremely difficult submission to say, well, somehow the court has got through the entire process of being asked and answering that question without alighting on the issue of whether claims against employees that would otherwise fall within 5.3 come within Section 5. Now, my Lord, the case comes back to the Dutch Supreme Court, and we've got the Advocate General's opinion at Authorities Bundle 4, tab 58, page 2492.
Thank you.
And my Lords, if one goes to 2497, at para 213, the Advocate General addresses the employee issue, and one detects there perhaps some degree of surprise that the Court of Justice had referred that issue back, because in this case it is not in dispute. There was an employment agreement between Mr. Spies and Holterman. And the issue that flew on the Commission's kite in the Court of Justice isn't even a live issue when the case comes back. But then 214, we would say the Advocate General absolutely understanding the effect of the Court of Justice, since there is an employment agreement, it follows that there's jurisdiction under Section 5, and the question of whether jurisdiction for claims may be based on Article 5.1 or 5.3 does not arise. So we have no analysis from the Advocate General of is there a 5.3 claim, because he correctly understands.
What did he say first time round on this point? Is it the same person?
My Lord, the first time round, I think, is at a little earlier in the bundle. Yes, tab 56. My Lord, 2426 is the Advocate General at para 1.4, referring to what the Arnhem Court of Appeal had found. And my Lord, the last paragraph there, the last line of 1.4, regarding Holterman Ferrer's claim based on tort, the Court of Appeal found that this claim is clearly connected with the claim concerning matters relating to an individual contract and cannot lead to the Dutch court having jurisdiction.
I mean, there's a finding at paragraph 1.1 that the parties had signed a contract of employment.
My Lord, that is right, and I have to say one looks in vain for any suggestion in the Dutch proceedings that is a live issue. It's simply one that the Commission come up with of their own motion before the Court of Justice.
I mean, was the point that the Commission raised whether, not so much whether there was an employment contract, but whether if you have an employee who is employed to be the boss, effectively the rationale of the special treatment of employees disappears.
Lord, I think that is right because of the lack of subordination, a subordinate role. The clearest explanation one finds is in notes 3 and 4 of the Advocate General's judgment in Holterman at
What page?
2343 to 4.
2343. Sorry, which note?
Note 3 sets out the fact of the shareholding and the fact that Mr. Spies had a management role. And then Note 4 summarises the Commission's submission that there was no relationship of subordination. And the argument may have been that if the only person giving instruction to Mr. Spies is himself,
So that would tend to suggest that in a case where the dominant factor was the functions that he was expected to employ, to perform, were essentially managerial, the analysis may be different from where it is genuinely where he's a rude mechanical.
well, it certainly allows that possibility, and one can see in the one-man company, for example, the argument that the relationship of the owner of that company and its sole director with the company was one of employment and subordination would be really rather contrary to the spirit of Section 5. Outside that extreme case, no doubt there are gradations, but ultimately it's accepted on the facts of this case that there was the power on behalf of the ultimate shareholder to hire and fire. So one issue we do not have in this litigation is that my clients were indeed employees. So, my lords, we say that Holterman, is the Court of Justice being asked and answering the first question of that arises on this appeal. That answer is very clearly that Section 5 precludes Article 5.3 claims as well as 5.1 claims if we weren't in an employment context. Sole question is whether Arcadia is seeking to establish misconduct on the part of the appellants in the performance of their duties. And we say plainly it is. And the common ground that all of the claims brought against them in tort concern conduct which would be a breach of their contract of employment itself answers that question. Now, we're criticised by Arcadia for not going far enough because it said, well, why do you really care whether the conduct would involve a breach of the contract of employment or not? Why don't you posit some other test of relationship between the tort claims and the contract of employment? Now, my lords, we accept there has to be some limit here. If I'm on holiday and I knock someone over and I get out and find to my horror or perhaps my delight it is my line manager, the coincidence of the employment relationship there is so completely extraneous to the tort of negligence in running him over that
You
we would
couldn't
not
base a claim on the contract anyway, could you?
Well, you're right. It's not a good analogy from that perspective.
Yeah.
But on any view, there must be some form of nexus because of the words relating to. They connote some causal connection.
Well, the only
between the
nexus
claims.
you argue for is that it should be capable of being viewed as a breach of the contract.
Well, all that is right. And that on any view must be sufficient to establish that nexus. And we do not understand it to be said that if Arcadia are wrong and that Section 5 covers some claims that otherwise might fall within Article 5.3 but not others, depending upon the nexus, that we somehow fall short of it. It is difficult to see what better connection you could have between the conduct giving rise to the tort claims and the contract than that conduct constitutes a breach of the contract of employment.
Can I ask you, in paragraph 41 of the judgment, the court tells us what the essential features are of an employment relationship, and they include, they are of it for a certain period of time. One person performs services for and under the direction of another, in return for which he receives remuneration. In the context of this case, who do you say the the CEO and CFO were acting under the direction of?
In practical terms, as the Court of Appeal found, it was Faraday, the ultimate shareholder, who had the power to hire and fire. That's in the statement of facts and issues.
Yeah.
Did you say they were acting for and under the direction of Faraday?
Well, they were acting obviously for the companies on whose behalf they were able to enter into contracts to commit those companies to oil trading contracts, sale or purchase. But in practice, the direction, the power to hire and fire, was exercised by the ultimate shareholder of all of those group companies, which was Faraday. Now,
And you say, I mean, that there can be an employment relationship without there being a contract. Insofar as, in this case, obviously, we're dealing with a whole variety of companies, and the individuals weren't in contractual relationships with all of them.
my lord, in English contract of employment terms, we accept that there was not a contract of employment with all of those companies.
Yeah.
It has been found at first instance, and there's been no appeal against this, that for national law purposes, the relevant employer was Arcadia London up until a certain date, then Arcadia Singapore, and then another Arcadia entity in Dubai. We do say that when it comes to applying Section 5, and this is on the second part of the appeal, the concept of employer has to be looked at more broadly than that in the group company context. And my lord, it's there that we rely upon the decisions in Semengo, Turner and Petter.
Yes. So when we see in paragraph 34 of the judgment here that the application of Section 5 arises only if Mr. Spies can be considered to be bound through an individual contract of employment to the company of which he was a director and manager, you say that's too narrow for the context that we're dealing with.
I'm conscious I'm now adopting the suggestion that was put to me, which I disagree with in an earlier stage. But I would say the one thing that the Court of Justice were not concerned with in this appeal was to address the group company type scenario.
Yeah. So paragraph 34 doesn't lay down an exhaustive formulation.
My lord, that would be our submission.
Mm-hmm.
And I'm going to come back at a later point just to pick up why we say that is the case, although we accept that that group company issue is not one which has really surfaced in the Court of Justice jurisprudence. There is a judgment which comes close to similar points in Pugliese, but it's appeared in the Court of Appeal when applying the convention here, but we're not aware of a Court of Justice authority that directly tackles the application of Section 5 in a group company context for our part. But we say nonetheless, as a matter of principle, the answer is clear enough to avoid the circumvention of Section 5 and to ensure that the intended purpose of that provision is met. But I was planning to come back to that in the context of the second part of the appeal.
That point applies to the conspiracy part of the appeal as much as it applies to any other part, doesn't it? I mean, the same point about the group companies applies to all the causes of action advanced, or it should do, shouldn't it?
My lord, it does. Because we've always lost the conspiracy point at first instance and in the Court of Appeal.
It doesn't have to be dealt with, or it wasn't dealt with in that context.
It just so happens that there's only been fiduciary duty left on the table when we got to the group of companies point. But I don't suggest the same point doesn't.
Now, I was a bit puzzled why the respondent's case didn't raise it in the context of conspiracy. as well, but it obviously does apply to conspiracy if they get that far.
My lord, it
If
does.
you get that far.
We don't suggest otherwise. If we had won on conspiracy below, one would have had the second argument fought on a rather wider front.
Yeah, right.
Yeah.
Now,
I'm not sure if you may be going to come back to this. I mean, the proceedings were actually brought by 4 companies against Mr. Spies, and he was, as I understand it, he was an employee of one of them, the others being subsidiaries of that company.
well, there were 3 German subsidiaries. Those claims were not pursued beyond the level of the Arnhem Court of Appeal.
Oh, I see. Right.
And that was one of those contexts in which all roads may not have led to Rome, but they did all lead to Germany, because it didn't matter in respect of the German companies which way you cut it in jurisdiction terms. It was going to be the German courts that would have jurisdiction. So by the time you get to the Dutch Supreme Court and the ECJ, it's only the claims brought by the Dutch entity, Holterman Ferro, that are still live before the court. So, my lords, we say Holterman provides the answer, and if we're right about that, one does not get into the underlying arguments about the relationship between Articles 18 and 5.1 and 5.3, because that question has been asked and answered. If we are wrong about Holterman, we then turn to the respondents' arguments on this point. My lord, to a significant extent, they are founded on the prior treatment of employment claims before Section 5 came into being, when it is said, and we accept that the special treatment of employees, if I can so put it, began as a court gloss on the place of performance of the obligation in question in Article 5.1. That gloss was then later incorporated into an express subdivision of Article 5.1. And what is then said is, when Section 5 comes into being, it is doing nothing more than confirming what has already been there.
It's a sort of subhead of contract.
The subhead of contract.
And the distinction between contract and tort is well established, they say, by history.
My lord, that's the argument. And it all turns on whether you can treat Section 5 as somehow not intending to expand upon or change the position as it prevailed when the jurisdiction of employees was dealt with solely by reference to an add-on to Article 5.1. Now, my lords, there's no dispute about the history on this. We're very happy to adopt, as the respondents do, a summary given by Advocate General Jacobs in Pugliese at paras 20 to 34. I'll give your lordship the reference to that, but I wasn't proposing to go through it because it isn't controversial. It's in Authorities Vol 3, tab 38, pages 2097 to 2101.
Yep. Yep.
My lords, where we part company is with the suggestion that you should interpret Section 5 on the basis that it wasn't intended to do any more than replicate the previous position. And it might be helpful then to pick up the Brussels regulation when Section 5 first comes in 2001, is in Authorities Bundle Volume 1. At tab 2.
Yep.
Beginning at 1066.
Good place. Good place to begin.
Certainly, my lord, there's a interesting historical parallel there. Obviously, recital 13 is on that page.
Yep.
Introduces the new Section 5, and significantly, we say, brackets it with Section 4 on consumer contracts and Section 3 on insurance, which were already the subject of special protective regimes rather than simply Article 5.1 add-on, and makes the point that they're intended to protect the weaker party.
Yep. Yep.
If one then goes forward to 1071, Article 18.1 has express reference back to Article 4, and point 5 of Article 5, branches and agencies, but otherwise no express reference back to any other part of Article 5. And that was an omission which the Court of Justice itself regarded as highly significant in the GlaxoSmithKline case, as we'll come on to, because the Court of Justice said that made it clear that you could no longer rely on Article 6.1 in employment claims as a result of this reconfiguration and sort of de novo addressing, as we would put it, of the position of employment contracts in a new comprehensive freestanding section, Section 5. Now, my lords, there are other new features that came in. We're not concerned with many of them. For example, the deemed domicile in Article 18.2 of employees established outside of any member state. But Article 20 is, we submit, very significantly changed from what went before.
Where do we have what went before?
And a copy of the original Brussels Convention, that's to say the 1968, or indeed the Lugano of 1988. We have got copies here for your lordships, and subject to my learned friend being content with that, I'm very happy to hand those up.
It might be useful, yeah.
That's all right, Mr. Foxon, is it with you?
No objection, but they are also set out in, or at least some of them, in the Advocate General's judgment in Pugliese, but I've got no problem at all with your lordship.
Well, don't hold things up. If the usher will get them, but let's carry on. Thank you, Mr. Rabinovitz. Yep. Yes.
Lord, Article 20 is significant in two respects. Obviously, when employees were dressed in the context of Article 5.1, that was an optional jurisdiction for an employer claimant to invoke, the alternative being jurisdiction under Section 2 or jurisdiction under an exclusive jurisdiction agreement reached between the employer and the employee. Article 20 is both mandatory and departed from previous wording, which referenced the concept of an habitual place of work. Replaced that with one of domicile. And, my lords, of course, that is the employee's domicile at the time the employee is sued. The employee may be an ex-employee who is sued, may no longer work for the company, or his habitual place of work may have changed. But nonetheless, in Article 20, you get this exhaustive definition of where the employee can be sued and a new test of domicile. So, my lords, we say that represents...
The domicile is the only test, then, is it?
It's the only test.
So if you have a case in which there are 4 or 6 or 10 employees all in the same conspiracy, you have to start the proceedings in 10 different domiciles, do you?
My lord, you do. And that is because this is a convention that isn't premised upon concepts of forum convenience.
Current method of going on.
So, my lords, we say that Section 5 represents significant and distinct change from the previous position.
Yep.
Now,
Do you accept, that before 2001, the distinction between contract and tort for the purposes of Article 5 depended on how the claim was formulated?
well, my lord, we then the question of what the right answer to that question is now depends upon how one interprets the decision in Brogsitter. And
I see that may have changed the position backwards, so to speak. What is the leaving aside Brogsitter, what is the previous authority? Do you accept that it's along the lines historically that the respondents suggest? I mean, they say it depends essentially on how it was formulated. If you were pursuing a tort claim, then it was a tort claim. If you were pursuing a contract claim, it was a contract claim. You couldn't pursue. There wasn't an overall analysis. It depends on how it was formulated. Is that wrong?
Well, we would say that before Brogsitter, there was a controversy as to the right approach. The Court of Appeal in this country, in Source and Ryland, had not committed themselves to the view that simply if you chose to plead the claim in tort and not plead the claim in contract, you fell outside Article 5.1.
Did they reject it? The Court of Appeal had rejected that proposition, had they not?
My Lord, they
have
did.
now. Sorry.
Well, I thought they had in Alpha Laval.
Well, Alpha Laval is obviously within the Section 5 context, because it was employment law claims.
Well, they rely. I mean, the respondents rely on Calphelis and Bankhouse Schroeder, don't they?
Lord, I accept that Calphelis plainly says you can't sort of piggyback your in that case, your non-tort claims on the back of a tort claim, and we will submit when we come on to Brogsitter that it addresses the pragmatic difficulties that arise when you have cumul claims, where you have the same conduct giving rise to claims in contract and tort, in a way which involves a departure from and an innovation as compared with the approach in Calphelis.
Anyway, you say we can forget about history.
Well, it's one of the areas where I agree with the Court of Appeal in this case, that the prior history sheds no real light on the resolution of the present appeal.
Can I ask, in relation to my Lord Clark's question, might Article 6 not give him some reassurance?
Thanks.
Now, well, so far as Article 6 is concerned, it was held by the European Court of Justice in GlaxoSmithKline that did not avail when you had to bring an employee into a jurisdiction that was not his own domicile. And it's important when we look at that. And the reason that they said that was because Section 5 was comprehensive and exhaustive. There was then an amendment to a future version, another version of the regulation, which applied Article 6 for the benefit of the employee. So an employee could sue an employer and then join someone in under, as it then was, Article 6.1, but not to the detriment of the employee, such that an employee could be sued elsewhere than in his or her own domicile. All of those, we say, strong pointers to quite how protective the jurisprudence of the Court of Justice is of an employee's right to be sued in their own domicile. Mr. Rabinowitz is absolutely right. The amendment wasn't made to Lugano. It's to the Brussels regulation recast. So in the Lugano context, we still have the GlaxoSmithKline rule that because there is no express reference to Article 6 in the introductory words of Article 18, it is ousted by
So there's no Lugano Convention recast.
Not yet, my lord. Now, my lords, if we could take up the respondent's case just briefly on this point, which is in Core 1, tab 8.
Can you take paragraph numbers rather than page numbers? Yep. No, we come to this, yep.
Lord, it is paragraph 22, subparagraph 6.
Thank you. Yeah.
And, my lords, as to the first of those points, subparagraph 6a, we say no, significant changes in section 5. Your lordships will form your own view about whether it was simply a repetition of what was already there before or not. Secondly, there's a reference to a case note on GlaxoSmithKline by Professor Harris, QC. Well, that quote does indeed appear. We've got that in volume 7 at tab 75.
This is what, footnote 43, is it?
Footnote 41.
41. Yeah. You're asking us to look that up.
I'm going to show you, Lordship, because I'm afraid the quotation is incomplete. 76, I apologise. That was it's volume 7, tab 76.
Yeah. Which page?
And it's page 3326.
Thank you.
And it is indeed the case that Professor Harris says the creation of a separate section in the regulation containing employment contract provisions was essentially a tidying up exercise and not a fundamental change to the jurisdiction rules. Well, we disagree with that for the reasons we've explained to your lordships. But he then says it was designed, if anything, to enhance the protection available to employees over the previous rather unsystematic convention protection, and a reference to recital 13. So insofar as any assistance is to be derived from that case note on GlaxoSmithKline, we would say it really cuts both ways. And, my lords, as I've mentioned, the case note was criticising the decision of the ECJ in GlaxoSmithKline for ruling that Section 5 now precluded an employee from being able to rely upon Article 6.1 in the way that the employee would have been able to before. So Professor Harris, I think, was criticising the reasoning that actually led to a reduction in the scope of rights available to an employee on that particular issue.
He was saying that they were wrong because they treated the change as being more fundamental than he, Professor Harris, thought it should have been.
Or at least if it was a change, it was certainly not to be a change that damaged the position of the employee. Indeed, at 3327, in the middle paragraph on that page, Professor Harris argued that you could interpret the regulation to give the employee the benefit of Article 6.1, but without giving it to the employer, because there may be a teleological reason why you could read it so as to benefit the employee as the weaker party without subjecting the employee to the risk of being sued elsewhere than his own domicile.
This is the paragraph beginning the ECJ proceeded to convince itself.
My lord, it is.
Yep.
And Lord, little comfort, we would say there, but it is of interest to look at the ECJ decision in GlaxoSmithKline, which we have in Authorities Bundle 3. Lord, at tab 40.
40.
Tab 40, page 2138. And my lord, the background was the claimant had been employed by one company and then another. And he wanted to sue the first company in the place of its domicile and join the second company to the proceedings using Article 6.1. And it was held that he could not. My lords, go to the reasoning at 2150.
Right.
If I could invite your lordship just to cast an eye through paragraphs 15 to 19 on that page. So My Lords, their reasoning is on the basis that Section 5 differs appreciably from the agreement before, and that it contains provisions that are not only specific but also exhaustive. So we would say taking a very different view of the relevance of the previous position to that which the respondents ask you to take on this appeal. And my Lord, if I just go finally on this to 2151, paragraphs 30 to 31,
Yep.
one of the reasons they give for that is that otherwise an employee could be deprived of the right to be sued in the courts of the place where he is domiciled.
Of course. Yes. Yeah.
So, my Lords, that is the argument from legislative history. There's also an argument based upon the principle of construing derogations from the general rule that defendants should only be sued in the places of their own domicile restrictively. It's an argument that arises via a somewhat ironic route here, because what is said is that because the same language determines not only when an employee must be sued in the employee's domicile, but also is relevant to language allowing the employer to be sued elsewhere than the employer's domicile. You must construe that language restrictively as a derogation from the general principle that people should be sued where they are domiciled. So that is the argument. My Lord, we accept that that is one of the interpretative canons that are available when construing the Lugano Convention and the Brussels Regulation. It is clear that another interpretive canon is the desire to ensure that provisions that are intended to provide protection to a particular class of litigants are interpreted in such a way as to afford those individuals with the protection the framers of the convention intended them to have. Whether one calls that a principle of efficacy. Now, there are a number of references to that principle. It ought not to be controversial as a generalized statement of one interpretive approach. And my Lords, given that, I was hoping to give your Lordships the reference to the supporting authority, but without necessarily going to it in the course of submissions. We would invite your Lordship to look at the Court of Justice itself in Mahamdia versus Algeria, Section 5 case, in Authorities, Volume 4, Tab 44, page 2241, at paragraph 46. In the insurance context, there's FBTO.
Paragraph 46.
Paragraph 46.
Yep. FPPO, yep.
At Appellant Supplemental Authorities,
Yep.
tab 4,
Yep.
page 123, paragraph 28. And, my Lord, there are similar references by Lord Justice Morbick and Lord Justice Sales in the Court of Appeal in Petter. My Lords, we do say that if you interpreted Section 5 as not applying to claims that would otherwise fall within Article 5.3, that would very seriously circumvent the protection which Section 5 is intended to give employees, namely the right to be sued and only to be sued in their own domicile.
Can I just... this is, in part, arises out of the intended protection of the employee and in part out of some points that you made about Holton. Harking back to the Commission's point in Holton, is it arguable that the use by an employee of a power of control over the company is not to be regarded as characteristic of the employment relationship, even if there is one, because subordination is treated by the EU jurisprudence as the essence of the employment relationship? So if, notwithstanding that you derive your powers of control from your employment, as for example Chief Executive, that is not treated as an employment claim at all, because control over the employment is regarded as something inherently different from the subordination that is inherent in the employment relationship.
Lord, I would accept that there are scenarios where one could have the contract of employment, and the one I gave earlier on was between the one-man company and the one-man.
That's a shareholder relationship.
Yes, but even if there was a contract of employment as well, one can see the argument that there is, in truth, no subordination there.
Yes.
And therefore you would not fall within Section 5.
But the only subordination you rely on here is subordination to the parent company and its owner. And I question whether that is necessarily a relevant subordination. One's talking about subordination to the person with whom you have the relevant contract of employment. And it may be thought that there isn't any if the allegation arises out of the way in which that occasions the exercise of control over your employer.
Lord, I have two answers to that. The first is that the Court of Appeal's description of being ultimately answerable to the ultimate shareholder with the power to hire and fire is simply because that is the person who de facto is exercising the employing entity's power of supervision. When you are fired, the person or the entity from whose employment you are fired is not the ultimate shareholder, but the various group companies for whom you're doing the work. So although
that just means that the ultimate shareholder is in a position to procure your employer to sack you.
But it reflects the very fact that your employer can be procured by someone else to sack you, and that is in practice how the Court of Appeal found the relationship work. We would say does establish the requisite subordination between you and the employing entity.
Does it?
Is that quite consistent with the way the court puts it in Holterman at paragraph 47 in particular, on page 2353? In paragraph 46, they say that the issue whether a relationship of subordination exists must, in each case, be assessed on basis of all the factors and circumstances characterizing the relationship between the parties being presumably the employer and the employee. And then 47, it's the referring court to examine the extent to which Mr. Speece was able to influence the will of that company, in other words, the employing company's administrative body, of which he was the manager. The administrative body, I suppose, being the board of directors, or the Dutch equivalent. In that case, it would be necessary to establish who had authority to issue instructions and to monitor their implementation. If it were to turn out that Mr. Speece's ability to influence that body was not negligible, it would be appropriate to conclude that there was no relationship of subordination. So it's not talking about ultimate shareholder control, I don't think.
Well, except Holterman is not. The ultimate shareholder comes in simply as a description of the fact pattern and the findings of the Court of Appeal here as to who Mr. Bosworth and Mr. Hurley in practice were answerable to in respect of their work, and who it was who would take the decision to get rid of them.
No, but why is that relevant? What is relevant, surely, is the position at the time he was doing the alleged defalcations. And if at that time he was in total control of everything, this paragraph would suggest that might mean that he wasn't to be regarded as an employee. It's irrelevant if at some future date somebody else can sack him.
But his employer could sack him at that date.
Well, no, I mean, it's most implausible he's going to sack himself if he's in total control of the company.
Well, we then come to what was going to be my second answer to Lord Sumption's comment, which is it is not disputed and is not a live issue before your lordships that Mr. Bosworth and Mr. Hurley were employees.
Well, that rather begs the question, what is meant by an employee or an employment relationship in the context of this kind of issue?
You can't have your cake and eat it, because you yourself say that the national categorization, which the Court of Appeal recited, is not the end of it. For Euro purposes, he's an employee of all sorts of people, you say, with whom he didn't have contracts of employment.
Well, the situation we have addressed is,
If that's right, he may be, for Euro purposes, not an employee of anyone at the relevant time.
well, that is not an argument that has been made, that he's not for Euro purposes an employee for anyone. Indeed, if that were right, the claims which the court has shut out at first instance during the periods of employment should not have been shut out, or there should have been appeal against those points. And well, it's not an issue that the cases address.
Well, we may have to address it.
Put it this way,
Can I just,
if one possible outcome of this case is for us to make a reference, we would look pretty silly if we made a reference without having taken a point which the Court of Justice would certainly take, even if the parties hadn't raised it.
Or at least the Commission.
Well, Lord, of course, that if the court makes a reference, it will want to make sure it's an effective reference.
Yeah.
But in terms of the issues that at least have arisen in the way the parties have formulated their case before the Lordship, there has not been an issue to date that Mr. Bosworth and Mr. Hurley are employees for Section 5 purposes, at least for parts of this appeal.
Well, can I ask you to consider another possible refinement, which is there a difference between the control that an employee exercises by virtue of his status as a shareholder, the control or the influence that he exercises by virtue of his status as a shareholder, and the control or influence that he exercises by virtue of his being a particularly senior employee? Because Holterman was concerned with an influence derived from the shareholding, if I'm not wrong.
And well, we would say there is a difference between those two. Senior employees can be given various amounts of autonomy depending upon the appetite of anyone else closely to follow their dealings. But when it comes to a situation in which decision is taken to fire someone, the employee is not in a position to control the taking of that decision. By contrast, if you are a shareholder with the ultimate organ of management of the company being the company in general meeting, there is a de jure power potentially on behalf of the employee to prevent the exercise of what would otherwise be the company's right to terminate employment.
Yeah, I can't see that the right to fire somebody has got actually very much to do with the issue we're concerned with. The real point of my question is that it might be said that an influence derived from one's status as a shareholder may be coincident with the status of an employee, but it basically got nothing to do with it, which can't be said of a situation where your control is derived from the employment relationship itself and from nothing else.
Well, there is that distinction, and there is also, we would submit a distinction to be drawn between what is a genuine de jure power of control and simply factual autonomy as a result of a way in which the person who could hold you to account chooses to exercise their power of supervision over you. And a light touch, we would say, cannot be enough to take the individual whom you could supervise much more intensely outside the protection of Section 5. Now, Lords, both sides have mentioned consumer contracts in Section 4. In view of the time, I'm not proposing to say a great deal about that.
Well, as I said, you produced, as has Mr. Rabinovitz and his team, a very full written printed case. So if you want to take us to refer us to that, that's fine.
Well, I think the key point we would want to mention is this, that what the cases under the consumer section do not address is the situation in which the consumer wants to bring a tort claim as well as a contract claim against the person who supplied the goods. So that if, for example, you have a sale of goods that falls within Section 4, offers sent to the consumer in the territory of domicile, etc., is it really said the consumer could sue in contract for goods being dangerous, but a tort claim that consumer wanted to bring would fall outside Section 4? There's no authority on that. There's academic commentary which would tend to support the view that the social purpose of the section should encompass the tort claim as well as the contract claim. But we would say that it would be very surprising in Section 4 if that was limited to claims that would fall within Article 5.1. Otherwise, the party who sold the dangerous goods could sue in tort for a declaration of non-liability, taking the consumer outside of the intended protection of Section 4. And similarly, in the employment context, we say again, very surprising if you could take the employee outside of the intended protection of Section 5 by choosing to bring a claim in tort from the concurrent claims in contract and tort that are available to you. But Lord, that apart, we submit you don't get a great deal of assistance from the Section 4 cases because none of them are directly on this point. Now, my lords, if we're wrong about Holtman and about Section 5 precluding Article 5.3 claims, if I can put it in that way, we then come on to the territory of what Brogsitter decides. And it's fair to say that the arguments on this issue before the court have a rather wider significance than simply employment claims. They would apply in any context in which the same set of facts discloses alternate claims in contract and tort. I'm going to use the shorthand cumul claims to describe that scenario. And it's clear that from a jurisdictional perspective, cumul claims present certain risks.
What's the definition of a cumul claim?
A claim where the same conduct gives the claimant alternative claims in contract and in tort. So I suppose Henderson and Merritt, in English law we do allow...
But that would be any cause of action, I mean, including statutory duty, breaches of statutory duty and so on. Any case which depends on the same factual
on the same
material.
conduct. My lord, yes. And my lord, the risks that those sort of claims pose for a convention are, first of all, the risk of unpredictability. If bringing the contract claim gets you into a different jurisdiction provision than the tort claim, and the claimant is given a choice as to which of those two to invoke, and that by definition generates unpredictability on behalf of the defendant as to where they can be sued. And generally, the framers of the convention and the regulation look to minimise unpredictability as to place of suit.
Well, it's more fundamental than that, isn't it? If you have a convention which requires you to distinguish between, for certain purposes, between tort and contract, and you have a national legal system which regards the distinction as being immaterial because you can choose either, the convention becomes rather difficult to operate.
Well, yes, one point we have made is it operates differentially between jurisdictions that do not allow concurrent claims in tort
Right.
and jurisdictions that do. So I certainly would agree with that formulation. It also involves the risk of parallel proceedings because you may have a party who might get a benefit in approach to quantification of loss in contract, but have a limitation concern where that party would be better served by suing in tort. And if those claims are sent to different jurisdictional gateways and different courts in the operation of Article 5, you then have another outcome that the convention is anxious to avoid, namely the simultaneous litigation in different courts of the same underlying conduct.
In practice, res judicata would determine the outcome of that conflict.
Well,
Certainly would under English.
so it might depend upon the approach under relevant national law. That unpredictability is enhanced because, of course, these categories apply not only to the party who suffered loss seeking compensation, but to the putative tortfeasor or contract breaker suing for a declaration that there is no liability in contract or in tort. And, my lords, we submit that what Brogsitter offers is simply a pragmatic answer to those concerns. It offers the easy answer. Well, look, if the conduct you complain of may reasonably be considered to be a breach of the contract between the parties, then both your claims, which under national law are contract and tort claims, will come within Article 5.1. Entirely pragmatic, I mentioned earlier on, to that extent, we say it represents a refinement or an innovation from the approach in Calphalis. It doesn't enable you to bring in any related tort claim on the back of a contract claim, or it asks the simple question, if the conduct that gives right to the tort claim may reasonably be considered to be a breach of the contract, Article 5.1 will apply. And those risks of lack of predictability and of inconsistent decisions or differential operation between different national systems, depending on whether they allow alternative claims or not, will be much diminished. So, my lord, that is our interpretation of Brogsitter. Arcadia would suggest it represents a sort of rather more conceptual distinction between what Professor Stevens describes as tortious conduct only actionable because of a voluntary undertaking not to do it, and conduct which is actionable in tort because you have a right against the world that you not be harmed in that way. Obviously, from an English law perspective, the classic distinction would be between the right not to have damage to your person or property caused by negligence, which is prima facie a right you have as against the world, as against claims dependent upon pure economic loss, where you will need something akin to a voluntary assumption of duty in order for the tort claim to be actionable. So, to some extent, the question before your lordships is whether Brogsitter is better seen as an exercise in pragmatism or the application of a, with respect, if this were the case, rather poorly articulated principle between those types of claim. Now, Lords, we've got Brogsitter at Bundle 4, tab 45.
Yes.
Lords, it is, Lordships know, no Advocate General's opinion, and those terse paragraphs on page 225.
How do they decide whether or not to have an Advocate General's opinion? Easy cases, they don't have one, or what? How do they decide whether to have an Advocate General's opinion?
I mean, certainly the approach is generally intended to be that if the case isn't raising any novel or difficult issue, you might dispense with one.
You can only do it under Article 20, paragraph 5 of the court statute, if the court considers that the case raises no new point of law. That's how it's put.
But as
And that's something I've learnt this morning.
As my lord will have seen, the commentators to Brogsitter regarded the case as rather more important than the court appeared to have done when dispensing with the need for an Advocate General's opinion.
Well, the trouble is that you may decide that it raises no new point of law, and then when you look into it after when it's too late, you discover that it does after all.
I think both sides would say it is an important case rather than simply some routine application of existing jurisprudence. Lord, the paragraphs are on 2250. We have crawled all over them between us, and I wonder how much juice there is left to be squeezed from the Brogsitter lemon.
Took quite a long time. It's interesting. It's a 2012 case, and it didn't get decided till March 13th, when perhaps they were a bit keen to get on with this by the end. Anyway.
Yes. I'm never certain whether that is a good sign or a bad sign in terms of the time taken.
Depends which side you're on.
Right, sorry, which
So-
we're looking at. We're going to crawl over another.
Two brief points on Paris 25. Obviously, we say that Paris 24 is the pragmatic response. There are two issues that arise on paragraph 25. First of all, there is the linguistic analysis, without which no
Yeah.
Russell's or Lugano case would be complete. namely the words a priori. And Lordship will know we say that they are in there as to reflect the fact that what is given are words of exemplification rather than exhaustive description. The respondents say, well, the German is grundsätzlich.
Grundsätzlich. No, grundsätzlich. Right. Where do we find that? Paragraph 25, yeah.
Paragraph 25, instead of a priori.
Yeah.
Now, my Lord, our understanding of that phrase is it's identifying something as the cardinal instance.
Yes.
The judgment, we suspect, was originally written in French because I think Judge Bonichot was the juge rapporteur, and the words a priori appear in the French version rather than en principe or some other language. So, my Lord, there is that linguistic question, which I think only avails itself of limited possibility for submission. I offer it up to your Lordship to make of it what you will. There is then this fact that Para 25 is not simply telling you that the a priori example is when you need to look at the contract because the contract tells you whether the conduct is unlawful or not. It also contemplates you need to look at the contract because the contract may tell you that the conduct is lawful. Indeed, that is given first, indispensable to establish the lawful or, on the contrary, unlawful nature of the conduct. My Lord, there are, of course, rights that exist against the world. The right not to have one's copyright infringed, for example, which are lawful if, by a contract, you have licensed someone on certain conditions or within certain parameters to use your copyright. So, well, whatever Para 25 is doing, we say it cannot be reflecting the distinction which Arcadia seek to draw between conduct actionable as against the world and conduct which is only actionable in tort against a party who's voluntarily undertaken a particular duty to not to act in that way. And that does appear to have been an issue lurking in the back of Brogsitter, because if one looks at paragraph 11 on 2248, one of the defendant's responses is, well, look, our contract covers different sorts of watch mechanisms from those you're complaining about. Now, my Lords, very briefly, we say first of all that the true pragmatic answer that is given by Brogsitter is that in Para 24. Para 25 is simply an example of a priori case. It is not an example that can be explained away on the respondent's new theory of conduct which is only actionable because of a promise or an undertaking. In practice, if you have a tort claim between two parties and the conduct that gives rise to it may reasonably be considered a breach of the contract, the court is always going to want to look at what the contract says. And that simple reality, we say, is reflected in paragraph 25.
I mean, it's a pretty broad proposition, isn't it? If you have a claim for allegedly infringing some right you have which is protected by tort, and if the defendant puts up a contract and says, no, this conduct is covered by this contract, then that's a matter relating to contract, even though you strenuously deny, as the claimant, that the contract has anything to do with it, and you may well be right about that. It becomes a matter relating to contract, even if you may prove only to have a claim in tort, and the contract has nothing to do with it. Does it go that far?
Well, inherent in any jurisdictional analysis is that one has to apply the tests at a stage when the facts are not known. Yes. And so there are many cases in which jurisdiction will be established on a particular basis, but it will turn out at trial that basis is not made out. the court applying...
No, but that begs the question. You have got a strong arguable case that the contract has nothing to do with it, merely because the defendant has a case which may also be categorised as a strong arguable case that a contract might have something to do with it. It becomes a contract claim.
Well, more than
and you're forced to sue under a regime because the defendant is preferred in this sort of situation?
Well, no, not at all. What would happen is you'd have one party saying this is Article 5.1 and one saying it's 5.3, and if it was in England applying the Canada Trust gloss, the court would ask itself whether the plaintiff had much the better of the argument that it was a 5.3, because the claim didn't constitute a breach of the contract, and if the claimant had much the better of the argument, jurisdiction would be established under 5.3, and the matter would proceed on that basis.
I see. So although it will be indispensable to establish the defence, nonetheless, for jurisdictional purposes, it's sufficiently arguably not a matter relating to a contract for it to go ahead as a tort claim.
Well, because in jurisdiction one always has to be able to decide issues on a practical basis that doesn't require the entire trial of the action to get there.
Yeah.
Now, my lord, that leaves Granarolo, which we would submit does merit some time. That is in Authorities Bundle 4 at tab 55. And Lord, it begins on page 2407. It's an action for the French law tort of rupture abusive, where in a long-standing business relationship, one party suddenly and without sufficient notice breaks off the relationship. And Lord, it was a case in which Ambrosi, who are a French entity, wanted to establish jurisdiction in France, which they did under Article 5.3. Granarolo, their supplier, who had broken off, they said, the business relationship, said, no, this is an Article 5.1 claim, and guess what? The place of performance is X works in our factory in Bologna, and therefore you must sue us in Italy. Now, Advocate General Cocotte, who gave the opinion, asked the relevant questions in a formula very similar to that adopted by Arcadia on this appeal. One looks at 2413. Some express reference to Grogsitter in 13, and I wonder if I could just invite the court to cast an eye from 13 down to 20 on that page.
13 to 20.
My lord, yes.
So be it. Yes.
This was about a statutory right to terminate a contract, effectively irrespective of its terms.
My lord, not to terminate a contract.
No, not a contract,
a
a relationship,
relationship.
a business relationship.
Yep.
And indeed, it's a manifestation, I think, of an ordre public notion that you need to have some stability in trading affairs.
They have a statute which is the opposite of what we decided didn't exist at common law in a case called Marks and Spencer's against someone. Yeah. Sorry.
No, but Lordship was absolutely
But at
right.
any rate, it is the legal basis of it is independent of the arrangements between the parties.
My Lord, it is.
That's actually the ratio, isn't it?
That's right.
It does reflect a sort of what French state at least sees as a higher public interest in stability, regardless of contractual provisions. Now, Advocate General Cocotte, as we've seen, asks herself the question Arcadia say you ask, which is, do you need to interpret the contract to decide this claim? And her answer is you don't, because this is conduct which is independently actionable in French law, with or without a contract. But the court does not say, well, look, Ambrosi, because you've not brought a claim in contract, it's Article 5.3 and you win. The court sends it back to find out if there may tacitly be something which meets the concept of a contract as autonomously interpreted under Article 5.1. One sees that on page 2418.
That's true.
At Paris 24 to 28.
This was the view of the court independently of the Advocate General.
My Lord, it was.
I mean, did the Advocate General consider this as a possibility at all?
I think she felt sufficiently confident that this was not a matter in relation to contract, that the alternative question which would arise, and if it is, where is the place of performance, was dealt with very briefly, as I recall. But I don't think she considered the issue of, well, is there a tacit relationship that may give rise to something that can be called a contract.
So, sorry, which are the relevant provisions in the...
It's Paris 24 to 28 in the judgment on
Right.
page 2418. I'm sorry. Mr. Rabinovitz suggests reading Para 22 as well, and I'm very happy the court should do so.
22. Action is contractual nature. It's a bit of a teaser. So, yes, I see. The point about paragraph 22 is that the concept of contractual is, to use the famous word, autonomous.
And a lot of that is absolutely common ground.
They were dealing with the possibility that in French law an arrangement might give rise to obligations without there being even an implied or informal contract, a concept which an English lawyer would have difficulty in understanding, but which in French law might make better sense, given that the rather greater formality required for contractual status in French law.
Lord, I think they're also influenced by the fact that there appear to be different classifications of similar provisions under different national
So
laws.
what's a tacit contract then?
I suppose it has shades of an implied contract, although that is a phrase with a rather undistinguished history.
A tacit contract means a written contract of employment with all the usual formulae that French law requires in such cases at the end of it. Does it not?
Lord, it's only contemplating a consensual arrangement that has come into being through a process of great informality.
I mean, it's rather difficult to grasp because presumably the last thing that French law requires for a remedy under the statute is a contract. It's not interested in that. It says what we're interested in. The whole reason why you need this remedy is that there isn't a contract.
Or contractual right.
Or a contractual right. And yet some European concept of... one gets rather used to the abbreviation, but some European concept of contract is introduced, across the whole sphere of a business relationship, or only subject to some sort of criteria of
what? We're looking at long-standing, good faith, regularity of transactions, etc.
No, my Lord, my ambitions, so far as Granarola are concerned, are of rather
Limited.
lesser ambit, which is that there is no doubt that Ambrosi, who after all wanted to bring this action in France, a place where they said the loss was suffered, was not founding its claim on a contract or something that was Article 5.1 contractual. It is equally the case that rupture abusive is not something which is only actionable if you have something that meets an Article 5.1 autonomous contract. Because the court doesn't say it's 5.1 or nothing at all. It contemplates that going back for the court in Para 28 to answer whether it's 5.1 or 5.3. So you have here conduct which is actionable without a contract, where the court contemplates that if nonetheless there happens to be something meeting the autonomous definition of a contract, then Article 5.1 is going to apply.
Well, what the concept is, you could have a consensual arrangement where the consensual element is binding, notwithstanding that national law, in this case French law, says it isn't a contract because it doesn't have the relevant bells and whistles.
And that is a wholly uncontroversial proposition, that something can be a contract for Article 5.1 purposes without it being a contract under the relevant national law.
Yeah.
But it's the way in which the independently tortious cause of action pleaded by the party who, after all, wants tort-based jurisdiction, they don't win simply because they've not alleged this is breach of a tacit contractual arrangement. The court sends it back to find out. And Lord, even further, they don't actually ask the underlying court to say, would this be a breach?
What happened then?
It simply goes back. Lord, I don't know what happened thereafter in the French court. I think we have the decision.
So we don't know what a tacit contract has been held to be then?
No, it's fair to say commentators on the decision suggest there was a fairly strong hint to the national court that it should somehow find a tacit contract, but it was left open to that court to decide on the evidence. So, well, we say that is a decision which is entirely inconsistent with the idea that only torts which would not be actionable at all in the absence of a voluntary undertaking fall within 5.1 on the Brog-Sitter analysis. It recognises that provided there is a contract covering the conduct which gives rise to the tortious claim, that will be enough to bring both claims within Article 5.1.
Why didn't they like French jurisdiction? It seems to, assuming that sort of motive plays a part at all.
Each party was arguing for the jurisdiction of their own place of incorporation.
Yeah.
Granarola or Italy, so they wanted contract.
This was ex hypothesi, a non-contractual right, what we would call a non-contractual right. It was, as it were, a statutory right. But you say because it was, as it were, based on the existence of a contractual relationship.
I'm not even sure it was based on the existence of a contract.
Right.
The court took the view that if a national court would find that there was a relationship between the parties that was contractual, that encompassed
obviously,
the complaint, that was enough. Sorry, my lord.
That was consensual.
Yes.
You have to have a body of consistent evidence about something.
Yes, obviously the French cause of action is premised upon long-standing business relationships. So to that extent, I think they would have required its long.
So if you win this case, where are these issues going to be determined?
In Switzerland.
And only in Switzerland?
As against my clients, yes. Now.
So I find Cookall's reasoning completely convincing.
My lords, I wanted to then say something about Arcadia's two principal arguments here, one of which is what I've called the claim actually made argument, the argument that you focus on that which has been put in issue, as it were, on the form by the person.
Look at the pleaded case, effectively.
My lord, yes.
Yeah.
And then the second is the actionable against the world argument, as opposed to actionable only because of a voluntary undertaking or promise. Before doing so, there are 3 points I would ask your lordships to note when looking at that part of the respondent's case. First, none of the cases that they cite are concerned with the very particular practical issue raised by Cumul claims, which we say Brogsitter was providing a pragmatic answer to. And to that extent, statements of principle in other areas are no doubt of interest and assistance. But one has to recognise Brogsitter is providing a very targeted answer to a very particular problem. My Lord, second, many of those cases, and I think almost all the commentary relied upon, is pre-Brogsitter in its origin, and therefore we would say is of limited assistance when wrestling with where we stand post-Brogsitter on Cumul claims. And my Lords, finally, there is extensive reliance on material concerned with choice of law and the interrelationship between Rome I and Rome II. And I will come back to this, but the practical consequences of sending cumulative contract and tort claims between the same parties from the same conduct to different jurisdictions are of a wholly different order when looking at issues of administration of justice than the issue of whether one claim is governed by the state of law A and the tort claim is governed by the state of law B. They raise very different questions, and therefore one should not allow the choice of law reasoning to dictate the answer in the jurisdictional context. Lord, I don't know whether that is a convenient moment.
It sounds as if it is for you, Mr. Hogston.
Well, Lord, anything that is convenient to your lordships will be convenient for me.
Well, then I'm sure that's a mutual convenience. If we rise now, we will resume again at 2 o'clock. Thank you very much.